Ready? Start. Sir, thank you for giving me the opportunity to speak on the company's bill stop. Sir, this house and the other house passed the Companies Act 2013 after an exercise of more than a decade stop. The Companies Act 1956 was replaced by the Companies Act 2013 after a prolonged discussion, deliberations with the industry chambers and all the stakeholders stop. After several recommendations by the Standing Committee, it went twice to the Standing Committee. Only in 2013, the 1956 Act was replaced by Companies Act 2013 Stop Stanza. Now the Act is notified only partially in 2013 and from 1st April 2014 the Act was implemented stop. Within a period of 6 months, the government has come out with several amendments to the Act. There are nearly 14 sections which have been amended stop. I do not see any reason for amendment of some of the provisions like removing the threshold limit for minimum capital required for private companies and public companies stop. The previous act clearly says that the private companies should have a minimum capital of 1 lakh and the public companies should have a minimum capital of 5 lakh stop. This was a provision introduced to curb the shell companies and to put restrictions while incorporating the company's stock. This has been removed and then there is no capital requirement envisaged in the present amendment for incorporating a company stock. Then the next amendment is not making the common seal mandatory stop. The common seal is a seal which authenticates all document of a company and that is a seal which is required to be authenticated and that has been made optional stop. I do not see any reason for this change stop stanza. Then I welcome that section 76A has been added to protect the depositors and to make the offence a cognizable offence under section 447 stop. We have to protect the depositors stop. Of course, the original section, which is section 76, has the provision to protect them, but now more transparency has been brought in stop. I welcome it stop. As far as section 188 is concerned, where an agreement to be filed in certain cases, special resolution was necessary, which was very important stop. That has been removed stop. If these provisions can be passed with an ordinary resolution, I feel that this amendment is not necessary stop stanza. Sir, an important amendment has been brought into section 143 of the Companies Act stop. The present act before amendment has made it mandatory for the auditors to report all frauds to the central government stop. Through this amendment, a threshold limit has been laid stop. Now fraud up to certain threshold limit only will be informed by the auditors to the central government and frauds below the threshold limit will be reported to the company by the auditors and to the audit committee stop stanza. Sir, I welcome the proposed amendment but I wish a rider because reporting of frauds irrespective of the amount involved to the central government would not serve any meaningful purpose stop. However, some aspects need to be looked into stop. One, reporting of frauds where key management personnel was involved is by very nature a serious thing and therefore should be reported to the central government irrespective of the amount involved. Stop. To the objective behind the provision could not be achieved unless an effective mechanism is evolved at the central government level to deal with the information on fraud received from auditors of various companies' stock. What is happening now and even earlier is this stop. As far as audit reports and CAG comment are concerned, the central government or the concerned ministry has to go through it and file their comments and lay them before both the houses. Stop. But I can say this from my experience that the central government I not looking into the various comments of the CAG and the auditors. Stop. By bringing this reporting provision, you should strengthen the mechanism to go through fraud and take action within the central government. Stop. Steno. The proposed amendment should also require to disclose details of frauds reported to the government that are more serious in the board's report. Stop. The board report should also contain whatever the auditor reported. Stop. Sir, the entire responsibility of detecting fraud has been given to the auditors. Stop. Auditing of a company is not a fraud detecting job. Stop. Now, in this bill, entire responsibility of detecting the fraud or the major responsibility and they must be liable to improve their internal control system. Stop. Steno. The Institute of Chartered Accountants has already issued auditing standards and the fraud reporting methodology incorporated in those auditing standards. Stop. Sir, detecting the fraud has been left with the auditors, which responsibility must also be entrusted to the management or its various officers like the managing director, the chief financial advisor, the administrator, etc. Stop. Steno. Sir, the next amendment which is important is diluting the provision relating to loan to directors have been exempted. Stop. I do not know why that has to be done. Stop. It is related to loans to directors, that is an amendment to section 185. Stop. Then there is proposed amendment to section 188. Stop. Provision for special resolution under section 188 should also be seen in similar context. Stop. Sir, SEBI continues to provide for the requirement of special resolution in the situation envisaged under section 188 would have made companies more transparent and encourage shareholders democracy in the governance of the corporates. Stop. It may still be appropriate to modify the clause to require the special resolution in case where related party transactions involve an amount above a certain threshold limit. Stop. Steno. In order to encourage transparency, explanatory statement as required to be given under rules to the shareholders should also state the criteria or the basis for the management for considering a particular related party transaction in the ordinary course of business and at arm's length. Stop. The SEBI requirements and provision under companies law also differ on definition of related party transaction. Stop. While SEBI has aligned recently the criteria for material related party transaction, There are a number of differences on the corporate governance requirements as well. Stop. The government should evolve a mechanism so that SEBI and the company's law requirements coverage in regard to listed companies and companies with significant public interest. Stop. This would greatly help in easing business in India as well. Stop. Sir, the other amendment are consequential. Stop. I welcome some of the amendment and I request the government to look into the provisions of section 143 and the special resolution. Stop. Stanza. With these few words, I support the bill and hope that the Honorable Minister will look into the suggestions and consider them seriously in the interest and benefit of the people of this country. Stop. The High Court upheld the acquittal of all the accused except the appellant and convicted the appellant 302. Stop. Stanza. The High Court had not exercised the caution that was expected to while dealing with the judgment of acquittal by the trial court. High Court was not justified in interfering with the well-considered judgment of the trial court is restored. Stop. Stanza. The well-considered judgment of the trial court has been upset by the High Court, and in its impugned judgment, the High Court relied on the complaint. Stop. There is hardly any consideration in the High Court's judgment, more particularly of the mix-up. Stop. Over.